Vikash, now you are from Himachal,
Yes, sir.
and after going through your biodata, you had done your BA LLB from Punjab University and thereafter LLM.
Yes, sir.
Have you done some practice, private practice as a lawyer or not?
Uh, no, sir. So I haven't practiced as a lawyer after my graduation.
Okay. Thereafter, you presently you are working as a civil judge. You
Yes, sir.
you you have been selected in MP, Madhya Pradesh
Yes, sir.
Judiciary. So still your training has commenced or yet to commence?
Yes, sir. So training has been commenced. I have joined on 4th of October 2023, and sir, now it has been around 1 month of training.
You have completed your LLM in which year?
Sir, I
Because
have,
please.
sir, in 2021, sir, I am pursuing my LLM, and sir, in 2022, sir, I have completed, but I have yet to submit the dissertation.
Okay. You had no interest in your doing private practice or to do private practice as a lawyer.
Sir, pursuing a lawyer in litigation is a noble profession, but I have
Hmm.
always aimed and dreamt of becoming a judicial officer.
Okay. Then you have already become judicial officer. Then what prompted you to again appear before the HP Judicial Services, and now you are appearing. You will be appearing in the interview. So what
Uh,
prompted you? In fact, what are the reasons which persuaded you to go for HP Judicial Services?
Sir, actually, I have always aimed to become a judge in the Himachal Pradesh, but
In your
sir,
own state, you got it.
yes, sir. Sir, but nowadays the competition of judicial service examination are very high. So when I graduated in 2021, there were no
Hmm.
vacancies notified for Himachal Pradesh Judiciary. So, sir, I
Okay.
thought that if I apply in other state judicial services, it will
Hmm.
definitely give me an edge when I apply here back in Himachal. So that's the
Hmm.
reason sir, I applied in other states, sir.
So will be in two two questions. In fact, I'm putting to you in this.
Yes, sir.
First of all, what is the requirement to issue ad interim injunction order against the opposition party? In other words, while issuing while passing ad interim injunction order against the party, what you would see as to what is the requirement, whether you have fulfilled the necessary requirement, what are the necessary ingredients to issue a ad interim injunction against the party who has not the for you.
Sir, first of all, under when deciding an application under Order 39, Rule 1 and 2, it is to be seen that there are three tests basically given by the Honorable Supreme Court, which has to be kept in mind before giving the relief of interim injunction. First
Hmm.
is, sir, there must be a prima facie case against the prima facie case in the favor of the plaintiff. Second,
Hmm.
sir, there must be a balance of convenience in
Hmm.
interest of the plaintiff. Third,
Hmm.
if the relief is not given, then irreparable injury or loss will be caused to the plaintiff. By keeping
Hmm.
all these three tests in the mind, application for interim injunction has to be decided.
What do you understand by prima facie case? What do you mean by prima facie case?
So by pursuit of the record of the case application, it seems to the court that the decision will be given in the favor of the plaintiff prima facie.
In Himachal, since you are coming, going to compete for the post here,
Yes, sir.
if a if an application is filed under Order Untali Rule 1 and 2 of CPC, seeking injunction in respect of a property, immoral property, and the
Yes, sir.
application is not accompanied by the necessary, copy of Jamwandi,
Okay, sir.
what will you be doing? And if your answer is that you will not be passing any order, then the reasons therefore.
Sir, first of all,
Have
I
you
can.
understood? Oh, yeah. Please
Yes, sir.
proceed.
Yes, sir. Sir, first I can ask the party to produce the Jamabandi documents of the particular property, if it is.
Why? What for? What for?
Sir, in order to understand that whether the person is in actual possession of that particular property or not,
Hmm.
like it is in his name or not, sir.
Hmm.
Then, if that documents has been produced, and after reading the record of the case,
Hmm.
if it appears to the court that the leave should be given to the plaintiff, then, sir, application of temporary injunction is to be decided, sir.
Hmm. What is the what is the importance of revenue record in this case copy of Jamandi? What is the relevancy thereof? Is there any relevancy with respect here to one is to identify the land, and you may say that
Yes, sir.
parties has corroborated
Dispute.
is its pleading with respect to the description of the land. What else is what else uh, is other you may say that factor which will help you.
Sir, the main requirement of Order 39 Rule 1 is that whether the property was in the possession of that particular plaintiff or not.
Okay. If it is in his possession, if it is in his possession, another party dispute it, what position of law you would apply? If a party has been shown recorded in the ownership as well as the column of possession,
Yes, sir.
other party disputes it.
Yes, sir.
Other party, let's presume that you have issued the notice and not passed an entire injunction order, and after that other party has also put in appearance, and he
Yes, sir.
disputes your correctness of the that those entries.
Yes, sir.
How which provision of law will help you in deciding the premise effect? Have you gone through HP Land Revenue Act?
Aspirant. Uh,
Land Revenue Act, HP Himachal
no,
Pradesh Land Revenue.
no,
No,
sorry, sir. Sorry, sir. I haven't read it yet.
you being from Himachal, you are required to go through it.
Yes, sir. I will read it, sir.
Section 45,
Yes, sir.
probably Section 45 of HP Land Revenue Act
Yes, sir.
attaches rebuttable presumption of truth to the latest entries incorporated in the revenue report.
Okay, sir.
I'm giving you the answer.
Thank you, sir.
Okay. So
Yes, sir.
these are the, since you are appearing for the post, which is in Himachal, and local laws are applicable. So if
Yes, sir.
you have not gone through it, it is almost paramateria with the Punjab Land Revenue Act. Have you read it? Have you read it or
No,
not?
no, sir. I
Punjab Land
haven't.
Revenue. It
No,
was
sir.
not in your syllabus. Okay. So I will advise you to go through the local laws.
Yes, sir.
Have you read the have you gone through the HP Urban Rent Control Act?
Yes, sir. I have read it, sir.
Okay. Now I am putting your question. Is there any provision in that act which enables a party to enter into some sort of, you may call it, arrangement before letting out the premises?
Yes, sir. Sir,
Hmm.
it is, sir, I'm not recalling the exact section right now, but
Okay, no problem.
yes, sir. But it is regarding where the premises is vacant with the landlord and he wants to
Hmm.
let it out for the residential purpose. He may seek the permission of the collector that he wants to let it out to
Controller,
another.
control,
Yes, sir.
rent controller,
Rent
not
controller, sir.
collector, but rent controller.
Yes, sir.
Hmm.
Rent controller. That
Hmm.
he wants to let it out to some other person for a limited period of time. Then an
Hmm.
arrangement can be made between these two, landlord and the tenant. And when the time period is completed as per the agreement, it has to be vacated by the tenant. And if he's not vacating, then the help of the rent controller can be taken.
I will also give you clarification with respect to your proof. Exact section is section 17 thereof.
Yes, sir.
It requires, it speaks of an agreement between the landlord and the tenant.
Yes.
Whatever terms and conditions you decide, those are incorporated.
Yes, sir.
And after the termination, after the expiration of the stipulated period contained therein,
Yes, sir.
if the tenant does not vacate the premises, that order will work as order for capital offenses.
Yes, sir.
So as far as these SP local laws, you being from Himachal, you are required to know these things. Because there are a lot of cases not here at Dharamshala or Mandi or other towns. There are maximum cases of Urban Land Control Act action law.
Okay, sir.
Yeah. Now let's come to the criminal side. You must have gone through the basic provision of confession,
Yes, sir.
perhaps section 24, perhaps it starts.
Yes.
What are the exceptions there too? What I
Exceptions.
mean, what I mean, if you are dealing with a case
Yes.
has come before you as a magistrate, and prosecution and police has relied upon the confession of the accused
Yes.
to prove that he has done this offense or committed forgery or committed theft or robbery. What safeguards you are required to take while relying upon the statement allegedly made under section 27 of the Indian Evidence Act?
Yes, sir. Sir,
Okay.
sir, basic requirement of Section 27 is that the statement must be made voluntarily.
Hmm.
So magistrate has to keep check that whether the statement was made voluntarily by the accused person while he was in the custody of a police officer or not. If this
Hmm.
because sir, the voluntariness is
What,
the
what,
heart.
what do you mean? What do you mean by voluntarily? And how you are saying that how his voluntariness could be affected? But are there some factors which affects one's voluntariness?
Sir, if magistrate, when the accused person is brought before the magistrate, he can ask the accused directly that whether he is making this statement with his own sweet will or not.
No, no. That stage will be at the stage of the 313. Then when you will be recording the statement of the accused under section 313. Then the evidence is already before you. I'm asking at the stage of at the time of let's go to the next stage. At the time of arguments or at the
Yes, sir.
determination of the case, conclusion of the trial,
Yes, sir.
you have to write a judgment.
Yes, sir.
What factors you will take into consideration as to whether the confession was voluntary, as you are saying. What are those factors which you would like to take out of review, which you would like to take into consideration to rule out the possibility of those factors which could affect the voluntariness of a person?
Sir,
Shall we
first
go
of
through?
all,
Please.
yes, sir. Sir, in order to ensure the voluntariness, sir, first of all, it has to be the magistrate can ensure that the confession is made in the immediate presence of the magistrate.
So you are coming at so. I am not asking about. I am not about judicial confession. My query is with respect to extrajudicial confession. You may
Okay,
you may
sir.
call it. You may call
Okay,
it.
sir.
It is not 164. You are recording it. Police has come to the police has. I have already put forth to you to the proposition that police have relied upon
Yes,
the
sir.
extrajudicial confession of the accused made
Yes,
during
sir.
the course of the investigation and not before the magistrate.
Yes, sir. Sir, even
Now,
in the
what are those factors? I'm asking you a question in another sense. What are those factors which could affect the voluntariness of a person, of an accused,
Sir, various
to
factors
rule
are
out the
there.
possibility? Please.
So that first it is to ensure that extrajudicial confession is made to whom? That the person whom the extrajudicial confession is made, whether he is a
Hmm.
trusted person or not,
Hmm.
and under what circumstances the confession was made, and how
Hmm.
reliable the person to whom that confession is made. What was the
Hmm.
relation between the parties, and
Hmm.
what was the requirement to make the confession? Every these circumstances can be taken into the consideration. Then, sir, apart from this, it is to be seen whether there is a threat, inducement, or promise was there,
Yeah. Yeah.
was
Yeah.
there, was
Hmm.
there while making the confession or not, or whether it was
Hmm.
made before the police officer or not. If it is made, then it is not relevant. So all these factors can be taken into consideration while deciding that the confession is relevant or not, whether it to be admitted.
And inducement, threat, and promise.
Yes, sir.
You know, are you required to take into consideration as to at what this point of time these type of these inducements and etc. had been exercised upon the case? Are you required to take into consideration as to whether at the time when he was making this confession was he still under the influence thereof?
Sir, as per sir requirements given under Section 24 of Indian Evidence Act, the inducement, threat, or promise, if it is coming from an authority and it is relating to the case or guilt of the accused, and it is of temporal nature, sir, then it is not relevant confession.
So anyhow, you want to say that at the time of making confession you have to rule out the rule out the possibility of these three four factors which could affect the voluntariness or free consent of the case. Okay, okay.
Yes, sir.
What else are the exceptions to it? If let us take it, can confession of one accused could be used against another accused? And if
Sir,
so, under what circumstances?
sir, there is a law over this particular issue. As per
Hmm.
sir, as per Section 133 of Indian Evidence Act, it states that
No, no.
confession.
Accomplice is a
Yes, sir.
witness. I am asking you about the.
Confession.
I am not asking you to quote directly the section of the act.
Yes, sir.
But I'm asking you as to what are the requirements. What are the basic requirements? If you come to the conclusion that a confession made by the accused against his co-accused could be relied upon, is there any
Sir,
requirement, specific requirement?
yes, sir. Yes, sir.
Hmm.
Sir, general rule
Hmm.
is that no one confess on the behalf of other person. But
Hmm.
exception is there under Section 30 that there are
Hmm.
certain safeguards which is given that
Hmm.
the accused who is confessing, he is confessing in the same trial where the in the
Hmm.
immediate presence of the other accused, and other
Hmm.
accused has the opportunity to cross-examine him, and it
Hmm.
is regarding the same offense, and the person who is confessing, he is affecting himself and also the other person.
Yeah. Correct. Okay. Now, in a criminal trial, there are certain general exceptions.
Yes.
In case of a person suffering from some mental ailment, you come across a case. There, the defense takes the plea that accused was at the relevant point of time. The accused is
Yes, sir.
insane, of unsound mind. Whether you can rely on what are the factors which you as a judge has to take into consideration to see the applicability of the particular section of the insanity, unsoundness.
Sir, the basic requirement, if a person is taking the defense of
Yeah.
unsoundness of the mind,
Hmm.
then it is to see whether the unsoundness of mind was at the time when there is commission of the offense or not. If
How you would interpret the how you would interpret the word unsound mind in legal parlance?
so, it is
How you
basic.
would interpret? How you would explain in your words uh, unsoundness of mind?
So unsoundness of the mind basically means legal insanity, that while commission
What is
of,
what is this is what I am asking you. What is legal insanity?
yes,
What is legal insanity?
so while he was committing that particular crime, whether he was capable of understanding the nature and the gravity of his act or not, that whether he was committing is an offense or not. So this is legal insanity and
Yeah,
unsoundness of mind.
correct. Default bail. Have you heard of it?
Yes, sir.
Under this provision, it is governed.
So it is governed under section 167 of Criminal Procedure Code.
Very correct. Whether it is indivisible right, I'm putting you the proposition.
So
At the time, at the time application is filed, stipulated period has expired,
yes, sir.
and in the meantime, prosecution files the challan.
Yes, sir.
What will the position? Whether his right has been defeated, indivisible right has been defeated or not.
Sir, if the time period as mentioned under section 167, 90 days or 60 days time period has been expired, and
Hmm.
the bail application has been forwarded to the magistrate, and after that,
Hmm.
if the charge sheet is being filed, then the
Hmm.
accused has got his right to get a default bail, and it
Hmm.
is indefeasible right until unless he breaks the condition of the bail.
Okay. Okay. If the prosecution subsequently comes with a plea, comes with an application seeking bail, seeking cancellation of bail, whether you will be competent as a magistrate.
Uh, Sir, in my humble opinion, I believe that if after the application of bail has been made to the magistrate, subsequently a charge sheet is being filed, then accused get a right of bail, and cancellation cannot be made by the magistrate until unless the
But but
condition.
but but, but earlier you had passed the order, mainly on the ground that taking the provisions of section 167 into consideration that stipulated periods maximum stipulated period has expired. Now prosecution is coming with the application that bail be cancelled. You say that you cannot review your order. This is perhaps is it
Yes,
is it your is it your point?
yes, sir. I'm so my point is that if the application of bail has been filed before the charge sheet is filed, then accused get a default bail, and it is
Yeah, indivisible
it's
right.
a,
Yeah,
yes, indefeasible right. And
and
subsequently,
subsequently. Hmm.
yes, subsequently, if an application is made that there should be cancellation of the bail, sir,
Hmm.
if if the accused person is breaking the condition of that particular bill, then
No,
it
no,
can
no,
be
no,
cancelled.
no, 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 no breaking of condition. No breaking
Okay.
of condition.
Yes, sir.
No breaking of condition. Prosecution has come up with the plea that earlier, he has been released by taking under the provision of so and so. Now we are
Okay.
coming with the plea that we have filed a charge sheet against the accused.
So if there are the compelling circumstances that that magistrate deems fit that he is to be again taken into the custody, then magistrate can pass an order and take the custody of the accused person, sir.
Okay. Now we are accused is tried for several offences,
Yes, sir.
more than one offence, and you find that accused has committed the offences and he is held guilty. What is the limit of punishment of offences made up of several offences?
Yes. Sir, as per Section 31 of Criminal Procedure Code, where an accused person is tried at one trial for several offences, then
Hmm.
in such a case, and if the aggregate punishment of these several punishment is exceeding the power of the punishment of the magistrate, then he can
Hmm.
do so, and there will be no invalidity of the sentence, provided if that such a sentence should not exceed 14 years of the imprisonment, and second, that it should not be twice as
No,
the
no,
power
no.
of the magistrate.
You are not having that power. You are empowered only to and pass sentence up to 3 years
Yes,
as
sir.
a magistrate. As a magistrate.
Yes, sir.
Is there any limit
So the limit
in the
is
option?
yes, sir. Limit of sir, I cannot pass a sentence in aggregate, an aggregate sentence which is twice the power of my jurisdiction. Like sir, I cannot pass a sentence of more than 6 years in aggregate, sir.
Sure. I will again ask one more question with respect to you must have gone through the provision with respect to approval.
Yes, sir.
Under what circumstances, what are the requirements if an accused, if the prosecution comes up with a plea that an accused wants to become a prover, what are the necessary uh, factors which you will, as a magistrate, take into consideration to allow the application or dismiss the application?
Yes, sir. As per Section 306 of Criminal Procedure Code, the we
Hmm.
yes, sir. So a person becomes an approver. He becomes a prosecution witness only in those cases where there are no sufficient evidences to convict that accused person. So if there
Hmm.
are already sufficient evidences available with the court to decide the
Hmm.
matter, then there is no
Hmm.
requirement of making any accused person as an approver.
What,
And
what steps you will take? What steps you will take if you come to the conclusion, yes, that he becomes to he allowed to become a prover. What steps the magistrate is required to take?
magistrate, sir, as per Section 306, he will examine the that approver as a witness, and he, after taking his examination and taking his evidence, he will forward the case to the court of session or the chief judicial magistrate as required.
Okay. If subsequently he retracted from his earlier statement made, then what are the options?
Sir,
Would it
if
be?
he
Hmm.
yes, sir, if he
Hmm. Please,
retract
please, please. Hmm.
yes, sir, if he retracts his statements later on in the trial stage, then
Hmm.
sir, then offense under Section 193 of Indian Penal Code it made out, sir, for making a false statement on oath, and he can be made he may be convicted under Section 193 of Indian Penal Code, and he can be tried for the offense for which he was charged with.
Okay. Okay. So that's all from my side. Bhargava,
Yes, I think Rajat sir, you may take over.
please.
Yes.
Pardon? Please.
Vikas,
Good afternoon,
thank you,
sir.
sir. Thank you, sir. Vikas, please tell
Yes.
me, uh, why I am still not convinced. Why did you not practice? Because you have a bright career as a litigation lawyer. Because I see that you're very good with studies and you have excellent marks. So why did you not practice, and why did you choose judiciary as your first preference?
Uh, y- yes, sir. Sir, actually, I have explored this option also, and I really felt that being a litigant and being an advocate is a very noble profession. But sir, in my humble opinion, it is not suited to me. The reason being that, in my opinion, a advocate does not see the parties in a neutral light. Since he is employed by his client, he will definitely favor him, and he cannot do justice in the case. On the other hand, sir, a judicial officer, he's a neutral party, and he sees both the parties in a neutral light, and he is unbiased. So he's in a better position to do justice in the case.
And I think if that is that, if you think that biasness, you should keep it aside, then you being appointed as a judge in a Madhya Pradesh High Court Madhya Pradesh jurisdiction would be more suitable, because there you would not be having any friends or family. But here there would be cases of your friends, family. Some of your friends would be even practicing in Himachal Pradesh. So that for that reason, don't you think that you are better off in Madhya Pradesh?
Sir, I believe that since I have studied in Punjab University, Chandigarh, so most of my friends are from Punjab and Haryana state, and I do not have much connection in legal field here in Himachal. And regarding the sir home district, sir, it is the policy as far as I know in Himachal that you will not get your home district when you become a judicial officer, sir.
Okay, okay. Can you tell me a recent Supreme Court decision on the right to privacy?
Recent, sir, it's K.S. Puttaswamy versus Union of India was in 2018, sir. It was regarding the right to privacy.
What was held in that case?
So in that case, the right to privacy was recognized as a fundamental right.
Okay. Can you tell me what is institutional reservation?
Sorry, sir, I am unable to recall this particular term right now.
What is the function of Niti Aayog, Vikas?
So the Niti Aayog is the think tank of the government. The job of the Niti Aayog to frame the policies for the working of the government.
And what is the full form of Niti?
It is national. Sir, it was National Institute for Training. Sir, I'm unable to recall.
Transforming India, National Institute.
Yes, transforming India.
Okay, okay. Yes. Okay. Can you tell me what is EO instanti? EO instanti in IPC.
Sorry, sir.
EO instanti. Have you heard of this term in IPC?
No, sir. Sorry, sir. I am unable to recall this term.
Okay. If we look at the preamble of IPC, it writes General Penal Code of India instead of Indian Penal Code. Why is it so?
Sir, General Penal Code, because sir, it is not specifically giving a complete law on a particular offense. It is just giving a outline of every offense which is mentioned there in the code, sir.
Okay. Can you tell me that whether theft of electricity can be punished under IPC?
Sir, theft of electricity is not punishable in Indian Penal Code, but there is electricity act that governs that particular theft of electricity.
Okay, please tell me an offense which is punishable at all 4 stages of it.
Sir, all 4 stages. Sir, I think it can be conspiracy offense of conspiracy to commit an offense, because at the very stage when there is an agreement to commit an offense, then it is punishable.
Okay, please read upon it. Okay, my next question is, suppose A kills B to offer him before Kali Ma. Okay, before Ma Kali, he wants to offer B, and that's for that reason he kills B. What offense did he commit?
Sir, it will depend upon the facts of the case, complete facts of the case, but it can come under the category of the murder, sir.
Don't you think it will be culpable homicide?
Yes, sir.
Don't you think it will be culpable homicide?
Sir, I think it can fall under the fourth clause of section 300, that where he is doing an act which is imminently dangerous without any reasonable cause.
Okay. Though I would not necessarily agree with you, but still. Yes. Tell me that a client appointed a lawyer, and after that he disclosed the fact that he had committed a crime. Okay,
Yes,
and then he changed his lawyer.
yes,
Whether that privilege is gone now?
sir. No, sir. So actually, it is the privileged communication as per Section 126 of Indian Evidence Act, and the previous advocate is still bound by this protective communication.
Okay, okay. What? How about the same case in which he had said that I am about to commit a crime, and I don't want you to disclose this?
Sir, if he has about to commit the crime, then it is a duty of that particular advocate to inform the proper authorities about the commission of the crime.
Tell me, Vikas, if a person is under the expectation of death,
Yes, sir.
he makes a dying declaration,
Yes, sir.
and then he doesn't die, whether
Yes,
that
sir.
dying declaration will be held to be valid?
Sir, in such a case where the person does not die, then his statement can be used for corroboration as well as contradiction.
So
But
whether it will be a valid dying declaration or not?
so it's not a substantive piece of evidence, sir. It's the circumstances that will be relevant only, sir.
Okay, and what is the evidentiary value of a sniffer dog's evidence? Do you know a sniffer dog?
Yes, sir.
What is the evidentiary value of that?
Sir, it is a corroborative piece of evidence because a dog speaks through his master, and since it is a hearsay evidence, so it can be used only for corroborative piece of evidence.
Right. And can you tell me if I'm giving you an example? Tell me that your friend has committed you when you had gone to the house of your friend, he committed a
Yes.
theft of a phone from you. Okay, and you have no evidence thereof. You somehow, but you have seen that he has fixed CCTV cameras in his house. So
Yes.
you trespassed into his house, obtained those CCTV footage by means of, I mean, wrongful method, of course, and
Yes,
then
sir.
produced such evidence before the court. Whether such evidences obtained by any wrongful means will be held to be admissible, especially in the case of India.
Yes, sir. So, in the case of the similar circumstances were raised in the case of Makraj Patodia versus R.K. Birla, where it was held that an evidence which is relevant, it remains relevant and admissible, and court is not concerned that how that particular evidence is obtained, whether it is illegally procured evidence or not.
Okay, okay. Can you tell me that yes, what is the difference between a confession and a plea of guilt?
Sir, plea of guilt basically, so confession is basically admitting that you have committing. So it is depend upon the stages of the crimes, because at the trial stage where the person is given the option whether he wants the trial or whether he pleads guilty, and there he states that he wants to plead guilty, then this stage is known as the plea of guilt stage. And confession is, it can be made to any person, like it can be made to magistrate under section 164 statement. Further, so it can be made to any other person, extrajudicial confession. So, sir,
Okay, okay. I have a follow-up question to that. That you said that during the trial he can plead guilty, right?
yes, sir, when charges are framed, yes, sir.
When he'll be asked that whether he pleads guilty or not,
Yes, sir.
then he can plead guilty. Okay, what about he says no, that I don't want to plead guilty, but after trial commences, he says that I want to plead guilty. Can he do so? Can the magistrate accept the guilt? I mean, plead guilty at a stage later than what is prescribed in CIRPC?
Sir, in such a case, it will, yes, sir, magistrate, in my humble opinion, I believe that the if the accused person is pleading guilty in while the trial is being proceeded, then the court shall record that plea of the accused person and will give the conviction as prescribed.
Okay, okay. Over to you, Arun sir, I think I'm.
So, as the Muslim community is against the Uniform Civil Code, so what are their basic factors that why they are against this particular UCC?
Sir, basic factors, sir, they are there is a misconception that the Uniform Civil Code is against their right to religion. They are they are seeing it as an attack on their religion, and that's why, sir, they are protesting against Uniform Civil Code.
Okay. So, do you see that once the UCC is being implemented in India, it will be beneficial for all the religions which are there in India?
Yes, sir. So it will be beneficial.
Okay. So, please tell me any three benefits which the Muslim community will be having from this.
Sir, the first and the foremost benefit is regarding the women empowerment. Right now, sir, the Muslims, they are Muslim male is marrying three females, and he is not four females, and he is not in a generally he is not in a position to take care of all of them. And if Uniform Civil Code is being implemented, it will do it will help in the cause of women empowerment. Yes, sir. So this is the first and foremost. Apart from it, sir, all the civilians, they will be under this protective umbrella of the same set of personal civil rights, and it will be more, we are moving more forwards towards the equality, and as everyone will be treated alike. Everyone will have the right of adoption that we do not have right now in Muslim community and the Parsi community. Apart from
Okay.
this, sir, yes, sir.
Mhm.
So apart from this, sir, there will be more of it will be a step toward modernization. So we see it as a step.
Okay. So, Vikas, my next question to you is that do you understand the term functus officio?
Yes, sir.
What is the meaning of this term functus officio, and do there is any exception to this particular thing?
Sir, functious official means when a judgment has been signed by the court, then it cannot be altered again once it is signed. It becomes functious officio.
Okay. And what are the
Sir,
exceptions to this?
Sir, exception to this is first, sir, in the case of review, when judgment has been signed, even then if we are there is option of review, so it is one of exception. And sir, other is that there is for the purpose of clerical and arithmetical errors, the judgment can be altered.
So, as you stated, review is one of the option is there that the court can again reopen its
Yes, sir.
judgment. Do the review can be taken up by the court suo motu?
Uh, Sir, there must be an application in order to get the relief of review, sir.
Okay. So, because if, for example, there is a particular judgment against which one of the party had filed an appeal and the other party want to go for the review, do it is possible?
Sir, here, sir, the parties, if it will depend which one of the option has been exercised first. If the review option has been exercised, then appeal cannot be filed in that particular case till the review petition is decided. But if appeal has been filed, then review petition is not available.
So, as you are in Madhya Pradesh, you are being posted there in MP.
Yes, sir.
So, because MP is a Hindi state, yes.
Yes, sir.
So, with respect to the review को हिंदी में क्या कहेंगे?
Sir, I think it's Punarvilokan. It is known as Punarvilokan.
Okay. Uh, Vikas, as you hail from Bilaspur, please tell me any three famous things from Bilaspur district.
Sir, there are a lot of famous things here in district Bilaspur. Sir, the most famous thing is first is the Sri Naina Devi Ji temple, which is one of the Shakti Peeth. Apart from this, there is Govind Sagar Lake, which is also very famous here. And sir, there is Bahadurpur Hill Station. It's the only place here in Bilaspur where the snow falls, sir. So these are three famous places here.
Okay. Okay. So, Vikas, as let us say that you are a judicial magistrate and you are actually a judicial magistrate.
Yes.
So, my question to you is that if a public prosecutor makes an application for the withdrawal of the prosecution,
Yes, sir.
okay, and you are the authority because without your consent, the withdrawal application will not be allowed. So, what parameters you will see before allowing that particular application of the prosecutor?
Sir, the basic requirement under Section 321 for the withdrawal from the prosecution, even Honorable Supreme Court has also mentioned in various cases that it must be in the interest of the justice. If the justice allows, if case requires that there must be withdrawal from the prosecution and it is in the interest of justice, then the court shall give his permission for the withdrawal from the prosecution.
Okay, and any other thing you will see?
Sir, I will also consider the stage at which the particular case is there. If it is in the judgment stage, and I think that there is requirement that a judgment has to be passed, and there is no compelling circumstances, then sir, I will pass the judgment.
Are you aware of any important case of Himachal Pradesh in which the prosecution is being withdrawn by the state?
Uh, Sir, as far as I know, state has permission of state is not required for the withdrawal from prosecution under Section 321. But sir, as I am unable to recall any such case right now.
So, as public prosecutor is a agent of the state, so how we can say that without the authority of the state, the PP is going to make a withdrawal applications? Do PP is competent enough to do that?
Sir, the role of public prosecutor is not merely that he's just a uh, puppet of a state government or he's not just a mute spectator of that particular agency. The role of the public prosecutor is to do justice. Even if it appears to the public prosecutor that the accused person is not he has not committed the crime, then he has also to take the side of the accused side, sir. So the role of the public prosecutor is not to convict the accused person, but to do the justice in the case. So that's the role of public prosecutors.
So, because and if the public prosecutor had made this application and this application is there in before your court before the charges have been framed and you allow the application, so what will be the impact of that?
Sir, in such a scenario, the accused shall be discharged from the charges.
Okay, and if the charges are already framed and then this application is allowed?
Sir, in that case, sir, the accused shall be acquitted from the case.
Okay, so my next question to you is that once a person, there is a very common note that once a person is acquitted or convicted, he cannot be tried for the same offense. So let us say that there is a person who is a victim, and against that person, grievous hurt has been caused to him, and there is an accused against whom a case of Section 326 IPC is there. Now you carried on with the case and you convicted that person under Section 326, and subsequently that victim dies.
Yes, sir.
Now, what the court is supposed to do?
Sir, as per Section 300 of Criminal Procedure Code, if such a situation arises, then court can further try him for the offense of the causing of death of that person, sir.
Okay. So, is it not against the rule that once the person is convicted for an offense, he cannot be tried again?
So it's an exception to this rule, sir.
Okay. Okay. Vikas, my next question to you is that as you again, I will be saying that you hails from Bilaspur. तो बिलासपुर की धाम में आपकी क्या खासियत? बिलासपुर की धाम.
Sir, first of all, I would say it's about the dishes that we made here in Bilaspur. And sir, if compared to other district dham, like sir in Hamirpur, it's more of sweeteners they use in the sweet dishes are there in Hamirpur. And if taste wise, sir, I really like Bilaspuri dham among others, sir.
Okay, so what is the difference in Bilaspuri dham and Hamirpuri dham?
Sir, in Hamirpur, first, sir, they will serve you the sweet dish. After that, they will give serve you other dishes. And in Bilaspur, sir, in the end, they will give you, in last dish is the sweet dish, and before they give you the other dishes. So I personally like that Bilaspuri dham, sir.
So this is the only difference you see, and any other difference in the cooking methods?
Sir, cooking methods, sir, I haven't seen the preparation of the dham in other districts, sir, so I cannot compare.
Okay, okay, very good. Vikas, just tell me any three famous international fairs of Himachal Pradesh.
Fair Fox. Okay.
Fairs, मेला जो
Fairs.
लगता है.
Okay,
Yes.
sir. Sir, there is, sir, there is a state level fair that
I'm
is
talking about international fairs.
international fairs. The international, sorry, sir, I'm unable to recall international fairs.
Okay, okay. As there is a bordering district that is District Mandi, which fair of District Mandi is very famous? Are you aware of that?
So, sorry, sir, I'm unable to recall.
Okay, okay.
So
So you,
Mandi ki Shivratri is very famous, sir. So is there any fair at the time? So
yes, it is also an international fair. Okay, so
okay, sir.
you are supposed to know these basic things.
Yes.
Anyhow, now let us come to the feedback